This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to speak about the fact that the equitable remedy of rescission is a remedy that must be used with care by insurers. In my opinion, insurers must use the rescission remedy with care. Insurers should never assume that the promise to pay indemnity to the insured under a policy of insurance can, with impunity, be broken by advising the insured that the insurer has rescinded the policy. Rescission without sufficient evidence is wrongful. Rescission without the advice of competent counsel is a tactic fraught with peril. Rescission without a thorough investigation is dangerous. Where no valid ground for rescission exists, the threat or attempt to seek such relief may constitute a breach of the covenant of good faith and fair dealing, which is implied in the policy, and expose the insurer to tort damages for that breach, including punitive damages. One plaintiff's lawyer became wealthy when he learned that claims people were given a rubber stamp that said rescission and had no idea what it was. He would take the claims person's deposition and ask them to spell the word. When the claims person failed, the bad faith case was established. When they spelled the word correctly, he would ask the adjuster to state the elements necessary to effect a rescission. Almost none could answer. California, with a draconian rescission law, still make it clear that if an insurer elects rescission without sufficient evidence, it will bring the wrath of the courts down and will be the basis for allegations easily proven of extra-contractual torts. If sufficient evidence exists, the rescission remedy will deprive the insured or the insurer of all rights under the policy. The court will conclude that the contract never existed and neither party had any right under the contract. The bases for rescission require the following elements. 1. Misrepresentation of material facts. 2. Concealment of material facts. 3. Mistake of material facts. 4. Mistake of law or fraud. In California, these bases are codified, and if the insurer was in fact deceived into entering into a policy of insurance it would not have entered into at all or on the same terms, rescission can be effected and will be supported by the courts. So an insurer, before electing to rescind, should only consider rescission of an insurance policy, whether the rescission is requested by the insured or the insurer, if it can establish, regardless of the jurisdiction, that the facts represented in the acquisition of the policy, that is, in filling out and signing an application, that evidence establishes whether a fact was misrepresented, that evidence exists that establishes that a material fact was concealed or misrepresented, that evidence exists that establishes that the facts misrepresented or concealed were material to the decision to insure or not insure, that there is evidence that the person seeking rescission did not have better knowledge of the facts claimed misrepresented or concealed, that a sworn declaration from the underwriter who made the decision to insure or not insure concerning the effect true facts would have had on the underwriting decision exists and is available for presentation to a court, a review of the policy application process, investigation results in applicable law by a competent insurance coverage lawyer in the jurisdiction where the policy was made or to be performed, the existence of a thorough investigation of the negotiations for the policy, and a sworn statement from the underwriter who made the decision to insure or not insure as to his or her reliance on the material facts presented and what different decisions would have been made had the truth been told. The codes and cases that are discussed in my book, Insurance Fraud Volume 2, 2nd edition, in detail when they apply to the facts of the particular case, can provide assistance to the person charged with making a decision to rescind or not rescind a policy of insurance. Some states attempt to control rescission by statute. These differ state by state. Some are detailed and comprehensive. Some make it relatively easy for an insurer to rescind, while others make it exceedingly difficult. Rescission in marine insurance is probably where the remedy of rescission of insurance was first developed. Marine insurance, that is, ocean-going or lake-going vessels, as the first type of modern insurance, is different from basic property and casualty insurance, and special rules relating to the enforcement of the contract of insurance and rescission apply. For example, rescission of property and casualty insurance requires that the fact misrepresented or concealed must be material. With regard to marine insurance, however, note that California Insurance Code Section 1904 allows rescission of marine insurance even if the fact misrepresented is immaterial. Property and casualty insurance can only be rescinded if the insured is asked a question that is misrepresented, or if the prospective insured knows that the fact not provided is material. Marine insurance can be rescinded even if the question is not asked. When rescinding or attempting to rescind fire insurance, a contract subject to rescission, and in an action or proceeding seeking relief based upon rescission, will not be denied because of a delay in restoring or in tendering restoration of such benefits before judgment, unless such delay has been substantially prejudicial to the other party. But the court may make a tender of restoration a condition of its judgment. When notice of rescission has not otherwise been given, or an offer to restore the benefits received under the contract has not otherwise been made, the service of a pleading in an action or proceeding that seeks relief based on rescission shall be deemed to be such notice or offer or both. The insurer in states like California need not return the premium. It only needs to offer to return the premium, because most people won't cash the check, because cashing a check would be acceptance of the rescission. So that the offer is sufficient. If accepted, then rescission is effected and there's no problem. Life insurance purchasers are given special rights to rescind a contract of life insurance in California by Section 779.14 of the California Insurance Code. Earthquake insurance is also subject to rescission. California created an earthquake authority to provide earthquake insurance for people who could not get earthquake insurance in the normal market. The statute requires that if there is an underlying basic residential property insurance, and if not, the authority is required to rescind. The statute requiring such a rescission provides, quote, the authority shall renew any policy of basic residential earthquake insurance, provided the authority receives payment of the applicable renewal premium on or before the expiration date stated in the policy. The authority shall non-renew, rescind, or cancel a policy if the property is no longer covered by an underlying policy of residential property insurance, like a homeowner's policy. The policy issued by the authority shall not provide coverage in the event that there is no underlying policy of property insurance at the time of the loss. In that case, any unearned premium shall be returned to the policyholder on a pro rata basis. Since the 18th century, and probably before, insurance has been considered a business of the utmost good faith. Parties to an insurance contract are required to deal with each other fairly and in good faith. Neither party should conceal any material facts from the other, nor should either misrepresent any facts material to the decision to insure or not insure. Although it appears to be relatively easy to rescind a policy of insurance in California, if evidence is available to prove misrepresentation, concealment, or mistake of a fact material to the decision to insure or not insure, rescission will only be enforced because equity requires fairness. California, by statute, recognizes that it would not be fair to require an insurer to insure a person who had deceived it about the risk it was being asked to take. California also believes it would be unfair for an insured to be bound by a policy of insurance about whose provisions the insured was deceived. The decision to rescind, therefore, must be tempered by the warning from the Court of Appeal that, quote, our conclusion here should not result in an assumption by insurers that policy liability can, with impunity, be avoided or delayed by asserting a claim for rescission. That is a tactic fraught with peril. Where no valid ground for rescission exists, the threat or the attempt to seek such relief may itself constitute a breach of the covenant of good faith and fair dealing, which is implied in the policy, and the commission of one or more of the unfair claim settlement practices prescribed by Insurance Code Section 790.03, subdivision H. This is a statement from Imperial Casualty and Indemnity Company versus Sagamonian, a 1988 decision of the California Court of Appeal, a case which took 15 years of my life before it was resolved. Whenever an insurer or insured attempts to rescind a policy of insurance, it must have conducted a complete and thorough investigation into the acquisition of the policy, the representations made by all parties before the policy was acquired, interviewed the agents, brokers, and insureds to determine representations made and intent of the parties. Then, after the investigation is completed, the party seeking rescission should seek the advice and counsel of an experienced coverage lawyer. Depending on the facts and the advice of counsel, rescission can be completed by letter or the filing of a suit seeking declaratory relief from a court of competent jurisdiction, affirming the opinion that the contract should be rescinded and the parties placed in the same status as they were before the contract was made. In the Sagamonian case, there were only two material questions asked in the application for insurance. They were, have you ever had a policy canceled or non-renewed? And have you ever incurred a loss prior to the inception of this policy? He answered both in the negative. The thorough investigation revealed that, in fact, multiple prior policies had been canceled and multiple claims had been presented, including on the date he signed the application to Imperial, he was handed a check by his prior insurer for a large claim due to a leaking roof. And that policy, which paid the claim, then non-renewed his policy because of the poor condition of the property, even before the loss. This was sufficient grounds to rescind the policy because the underwriter testified that had she known the true facts, she would never have issued the policy at all. At the terms and conditions it was issued based upon a belief of the truth of the facts stated in the application. Imperial versus Sagamonian is the leading case in California on rescission, and I commend it to you. For a full reading of the total text, this video was adapted from my book Insurance Fraud, Volume 2, How Lawyers and Claims People Defeat Insurance Fraud, available as both a Kindle book and as a paperback from Amazon.com. If you're interested, you can obtain this book, and you can obtain from Amazon.com also my book on rescission, which is also available and provides you with more detail, including full text of important rescission cases from Amazon.com. If you found this video to be useful to you or your colleagues, please pass it on. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn of future videos and blog postings. Thank you for your attention.